afternoon, I'm Ann from Channel 6 News reporting live from SK. Recently, an issue has arisen and been in the minds of every citizen. I am sure that we are all on the same page as I am speaking right now. The burning question is whether
Wait, what is public interest immunity?
Oh, public interest immunity is a mechanism for the non-disclosure of sensitive materials to the defense. This continues to create it's a concern as a potential source of injustice.
I see.
They should not have disclosed this private report in court.
Human rights, human rights. Human rights, human rights, human rights.
Public interest is in the welfare of the general public. According to the journal by Zuckerman regarding public interest immunity, when the government is asked to disclose information, the scope of their duty is to decide whether the disclosure is injurious to the public interest. And if they believe that it is against public interest, they can make an application to the court to withhold the evidence. Whether the claim is approved to suppress the evidence is rested within the courts. If the application is acceded, public interest immunity will be granted to the government to not disclose the information to court. Information that is known to be sensitive should not be disclosed, such as areas concerning national security, international relations, or matters that would affect proper functioning of the public service. Because to disclose the sensitive documents would be contrary to public interest. Government in deciding whether to disclose the information will apply the public interest test and consider whether public interest outweighs the interest in disclosure for the administration of justice. This test requires the public authority to examine the harm that disclosure would cause to the public interest. Thus, this would place the government in a very difficult position. There must be a balance between the public interest to withhold information and the interest of justice to disclose. Therefore, the concern of government is that to what extent the information can be disclosed while taking into account public interest. If the government reveals information that is beyond the scope of public interest, it might affect the functioning of the state. For instance, if government discloses classified information and is revealed to the media, the safety of the country is at risk. As Lord Temperman expressed in Wiley, a claim to public interest immunity can only be justified if the public interest is preserving the confidentiality of the document outweighs the public interest in securing justice. In other words, the concern of the government before disclosing an information to a court of law is whether public interest outweighs the confidentiality of the document. As government concerns the welfare of public in the disclosure of materials, human rights come into play. Article 8 of the Human Rights Act 1998 provides the rights to respect for one's private and family life, his home and his correspondence. The article helps in protecting the identity of individuals enriched by virtue of the article. Public bodies are under a duty not to disclose information in court. However, the extent to the disclosure of information is provided in Article 8, subsection 2 of the Act, which states that there shall be no interference by a public authority with the exercise of this right except such as is in accordance with the law and is necessary in a democratic society in the interest of national security. public safety or the economic well-being of the country, for the prevention of disorder of crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. This principle provides protection for the individual where the state is under a duty not to reveal the identities of an individual unless there is an overarching reason for the disclosure and that the reason is justified.
Good morning, Your Honour. Ladies and gentlemen of the court, I need to bring forward a pressing matter. May I request that the government accounts be disclosed?
Your request for the disclosure is granted.
The government's accounts show that the government is so inefficient. I have to lodge a complaint.
According to the article by Zuckerman, where governments are required to disclose information to a court of law, conflict of interest that affects the proper functioning of the public service may arise. This is said so because when the government is required to disclose every information that they have without any restriction to the public, no matter what the content is, the government will not have the discretion to filter and select the type of information to be published. As a result, government do not have the authority and credibility that they should have when exercising their powers, and they might get threatened by those uncertain or unclear notions that disclose to the public. Not only that, conflicts that arise will not be resolved effectively, will create a deteriorating environment, consequently allowing abuse of public office, unlawful action, or breach of trust to ensue. Predominantly, the major aftermath will be a condition where the citizens lose confidence and trust in government. Hence, it shows that conflicts of interest have become a significant issue of a concern by the government when disclosing information to a court of law. Moreover, criticism and opinions might be raised by the public, resulting in serious consequences that might lead to social disruption. If there is an uncertain information disclosed to the public, it might reveal an inefficiencies and lay government to the society and expose to criticism. Hence, our nation's political status will become unstable as the society may request or even rail for a change in government to get a new transformation. Therefore, some of the information deserve immunity in order to prevent disclosure, which will affect political matters. This can be shown in Conway and Rimmer. House of Lords held that courts are the final arbiters who decide whether public interest immunity should be applied in the case. Next, if information of those which are private and confidential are disclosed in court, the privacy of the accounts of a business, for instance, might be affected. There is some information that the government should keep transparent to citizens. However, there are also information that should be disclosed. For example, according to government information laws, government have to proactively disclose information such as services that are offered by them, illegal conduct, improper management of public finances, maladministration, and directory of their public sectors. Government should ensure unity and a proper standard of openness of the information, and this can be related to the Australian case, Spencer and Commonwealth of Australia, where it was concluded that a class of documents that will affect public interest and reveal the deliberation of the government should have protection from disclosure to prevent chaos to occur. the criminal informant.
Good afternoon, Your Honor. I feel that you should not disclose my client's identity.
This is an order.
I'm sorry. Really, I'm sorry.
You betrayed me!
Under the Criminal Procedure and Investigations Act 1996, sensitive materials which include information relating to the prevention, detection, and investigation of crime must not be disclosed when the court concludes that it is not in the public interest. The most common cases involve the disclosure of identity to police informants. There is a clear public interest to not disclose material that may expose to the police informers, as the disclosure might affect the correctness of adjudication in the case and lead to the innocent being convicted and imprisoned. It nevertheless contradicts the principle of common law of open justice, which requires that maximum disclosure to take place. An example can be seen in the case of Perry and UK in 2004. In this case, the courts refused to disclose information to a court of law in order to protect the personal information of those who had been compelled to provide such information by the state, for instance, criminal informants. Moreover, the government might be concerned if they are required to disclose every information to a court of law when the document is related to confidential documents, such as police reports, manuals, and methods. Reports between the police forces and DPP or CPS might be too private to be disclosed, as the manuals and descriptions of police methods in dealing with crowd control, demonstrations, and riot. This ensures that the tactics used are not exposed. The Criminal Procedure Rules 2005, Part 25(4) plays a vital part when an application of public interest immunity and specific disclosure is made. According to The Guardian, identities of a victim of a stranger rape should not be disclosed to prevent them from unnecessary dangers. On the other hand, Article 6 of the Human Rights Act 1998 states the right to a fair trial. This is where the Human Rights Act provides a balance between the law. In relation to the extent where the government may be required to disclose information to a court of law, the government will have to disclose the information to the extent where this information would provide justice and would achieve the Article 6 of the Human Rights Act 1998. While the right to a fair trial was obtained, the court could disclose the information if it fits under the requirements laid under the Attorney General's guideline, which gives the disclosure of information in criminal proceedings. The House of Lords, in the case of Regina N.H., said that a trial judge should consider all the information that are available based on the nature of public interest immunity pursuit, as well as making sure that the complete process of the disclosure does not reveal more than is required given the context of the case.
In light of the recent terrorist attack that happened, I would like to request for governmental documents to be disclosed right now.
I would like to clarify this is a matter of national security.
As this is a matter of national security, the documents are not to be disclosed.
Disclosing information to a court of law inevitably causes concern regarding national security, particularly if the extent which it may be required to do so is vague and uncertain. If the government body has revealed classified information that has the potential to be taken advantage of by other parties with the intention to cause damage to the country, the national security of the country has been affected. Evidently, if the government discloses paramount information, a country susceptible to harm is is created. Hence, national security is indeed a crucial element in every country. National security is defined as the duty of the government to protect the country, its citizens, the economy, and institutions. In the United Kingdom, the main threats to national security are terrorism, cyber threats, espionage, and the proliferation of weapons of mass destruction, many of which destroys the UK's national infrastructure. In the case of Conway Agreement, there was a dicta that stated that it is the ministerial discretion to withhold evidence on grounds of national security. This view was manifested by the House of Lords in Council of Civil Service Unions and Minister for the Civil Service, where it was stated that the decision on whether the requirements of national security outweigh the duty of fairness in any particular case is for the government and not for the courts. The government alone has access to the relevant information, and in any event, the judicial process is unsuitable for reaching decisions on national security. However, in the case of Manchis Churchill, the trial judge overturned the public interest immunity certificate that was acquired on grounds of national security by the government to suppress critical evidence. This resulted in documents being forcefully handed over to the defense and the trial continued. This also caused a controversy about ministerial responsibilities with regards to public interest immunity. Nonetheless, public interest immunity based on national security was upheld once again when Lord Justice Rushlow emphasized in Balfour and Foreign and Commonwealth Office that once there is an actual or potential risk to national security demonstrated by an appropriate certificate, the court should not exercise its right to inspect. It is important to bear in mind that the court have not been abdicated of its responsibility, but merely recognizing the constraints placed on it by the terms of the certificates issued by the executive. Thus, an information in question will become inaccessible once the words national security is expressed by a minister, even if it is in the interest of justice.
I would like to request for the trade documents to be disclosed.
No, that ain't it. This will disrupt the well-being of my country.
My country's relations with other countries will be disrupted as well.
International relations is a crucial aspect in order for a country to thrive. Not only is it beneficial financially speaking, but it provides knowledge. Knowledge traded from other countries, teaching them culture through human interaction, as well as being able to tackle world problems together, such as environmental problems. International relations is becoming more inevitable. Technology is rapidly increasing, the world is becoming more and more interconnected. The expectation also protects the UK's relationship with these organizations, which are important means of defending and promoting UK's political and economic and other interests. There needs to be some sort of discretion from the case-to-case basis. If not, relations between countries would be a problem, forming grudges and not being able to advance as humans together. Government officials has the power to disclose certain documents in some instances, as seen in the Environmental Information Regulation 2004, Section 12, subsection 5A, where they state that a public authority has the power to refuse to disclose information that would adversely affect areas covering international relations, national security, and as well as public safety. The EIR, Section 12, subsection 6, this continues to say that the government officials has the right to confirm nor deny that such evidence does exist. In order to invoke the regulation of the EIR, Section 12, subsection 5A, international relations, defense, as well as national security or public interest, disclosing the requested information from these categories must have an adverse effect in order effect on them. To summarize, Section 12, subsection 4, and Section 12, subsection 5 required public authority figures to confirm or deny whether they hold said information, whereas Section 12, subsection 6 allows public bodies to confirm nor deny that the requested information. To further my point, it can be seen by the University of East Anglia, the UEA. The UEA requested the data on the climate change from the National Meteorological Services, but they promulgated that public authority has the power to decline any request to disclose information that could potentially cause any adverse effects regarding any international relations, as well as national security, and previously mentioned under the Environmental Information Regulation, Section 12, subsection 5A. The Commission accepted to disclose any of these information because it could potentially cause any problems towards any of the international relations, because it could jeopardize future relations between the UEA and the National Meteorological Services. By them not being able to possibly work together with other academic institutions, they brought the defense under the Freedom of Information Act, Section 40, subsection 2, where they state that the disclosure of information would be contrary to the requirements of the General Data Protection Regulation. In more recent cases, government officials is facing a lot of backlash due to the recent end to Brexit. They are now refusing to provide any information regarding the issue. They would not even release any basic information which focuses on the progression of the work aimed towards the delivering of the UK's departure from Europe. An adverse effect on international relations does not need to be measurable in terms of tangible or material loss, nor does it have to be immediate.
An exclusionary standard of evidence is what is being used to describe public interest immunity. Before public interest immunity became what it is now, it was once known as the Crown Privilege. The preamble to Section 28, subsection A states that the principal approves the non-disclosure of information or records important to case on the premise that divulgence of such proof is against the public interest. As per the doctrine of the Crown Privilege, just only the Crown could apply to the court quash proof on this premise, being acknowledged that clerical affirmation or endorsement such that the creation of certain proof would be in opposition to the public interest. In the case of Dunkard versus Camel Law 1942, the House of Lords held that irrespective of whether the Crown was involved with the procedures in a specific case at risk to creation ought not to be delivered if the public interest necessitated that they should to be retained. A document could be retained either in the light of fact the exposure of its substance would harm public interest. The ruling resurfaced in the case of Cornwell versus Rimmer in 1968, where the courts decided to depart from its previous precedents and ruled it was for the courts, not the individual trying to avoid disclosure, to administer on the contending public interest in the administration of equity and classified data. The Crown Privilege was later superseded by the phrase as public interest immunity, which empowers any party or observer in any procedure to apply for non-disclosure. This can be seen in the case of R versus Louis Justices, ex parte Home Secretary in 1973, where Lord Simon of Glansdale said that the public interest, which demands that the evidence be withheld, has to be weighed against the public interest in the administration of justice, that courts should have the fullest possible access to all relevant material.
Apart from the civil proceedings, which has been what public interest immunity is mainly concerned on, there are as well case laws on criminal proceedings. One of the most notable is the Matrix Churchill trial in 1987, where the directors of an engineering company was charged for selling parts to make firearms to the Iraqi government. The problem was that the prosecution chose to drop the case rather than disclose information that is necessary to the public knowledge. This then infringes the rule of law, which demands an open government and forbids secrecy, where discovery is in public interest. This concern was later addressed in the Scott Report 1966 by Sir Richard Scott that criticizes that the outcome of the Matrix Churchill trial was unreliable and brings up three major issues which prioritizes ministerial accountability, freedom of information, and the abolishment of class claims. A succeeding case that involves criminal matters is R versus Chief Constable of West Midlands Police, ex parte Wiley, where it lays down contemporary vivid guidelines for following criminal proceedings. The court's present perspective on class claims to public interest immunity is very unpredictable and still very complicated. It has been expressed on a few events that where disclosure is imperative in the interest of justice, asserts that documents be retained on the ground that their divulgence would hinder journalism of correspondence are probably not going to succeed. The public interest immunity has been developing for the past 23 years, and the judges are still progressing in finding a sweet spot for the public interest as well as disclosing relevant information.